Welcome to Detroit Auto Accident Law with Ravid and Associates.
Hello, everyone, and welcome back to Detroit Auto Accident Law with the trial lawyers of Ravid and Associates. Ravid and Associates is a Michigan-based personal injury firm that's fought for more than 10,000 accident victims statewide. Today's guest is Mark D. Foreman, an attorney at Ravid and Associates, who focuses on personal injury, wrongful death, and motor vehicle accident cases, with decades of experience handling serious, high-stakes litigation. I'm Sean O'Connor, and today, Mark and I are talking about what actually determines the value of a car accident case in Michigan and what can reduce it. Mark, good to see you.
Good to see you as well. Thank you.
Let's get into it. When you evaluate a car accident case, how do you start thinking about what drives its value overall?
Well, the first thing I always do when I work with a client is find out about their injuries and what happened in their accident, and perhaps spend some time getting to know them a little bit as well. That's always very valuable in developing a relationship with a client early on, especially in your first visit. So in determining the value of a case, I guess the two major components of any case are damages. In other words, what are your injuries? What have you lost in the accident? And liability, who's at fault? Okay? Sometimes people think because they have a very serious injury that alone is enough to make for a successful case, but that's only half of the equation. The other half is who's at fault and why are they at fault? So I have to prove both ends of the case in order to be successful for them. So determining the value of it, how serious are the injuries? I guess in a more commonplace analysis is what are the policy limits involved of the other party, and perhaps the uninsured motorist provision of my client, because that puts a ceiling on what you can collect. Even though you could collect on a person individually, most lawyers will not do that because, quite frankly, most people can't be collected upon individually. You're working with whatever the policy limits are. So that's an important question to ask right from the get-go as well.
You mentioned injuries, Mark, earlier, and how, sometimes people think, oh, I've got a serious injury. That's sort of an automatic win for the case, so to speak. How do different types of injuries tend to change how a case is viewed or valued?
Well, one of the terminologies that insurance companies like to use, and by that I mean claim adjusters and defense attorneys, is what we call objective versus subjective injuries. A subjective injury would be a person saying, I'm in a lot of pain, I really hurt, I can't do this, I can't do that. An objective injury is one that is provable by medical testing. And when you have an injury like a back or a neck injury, cervical spine, lumbar spine, thoracic spine, and you can document those injuries with objective medical testing, then that makes a much bigger impression upon the defense side. Because now they're not just saying that you hurt, they're seeing why you hurt. And plus, these are tests that really cannot be argued. An MRI film is an MRI film. A CAT scan is a CAT scan, and they can be reviewed by any doctor, and presumably they'll come up with the same conclusions. So if you can document your injuries with objective test results, now X-rays are probably the least effective of those, but the most important ones would be MRIs, CAT scans, ultrasounds. If those show what your injury is and why you have that injury, then you're a long way towards getting a very good settlement in a case.
Got it. That makes sense. So let's talk liability. You were mentioning, limits, insurance limits, that sort of thing. Where does liability come into play when it comes to case value, especially if fault is disputed or maybe fault is shared?
Well, the first and most important thing that I want in any car accident case is a police report, okay? Now, while a police report is by definition hearsay, it's still the very first marker of what happened in the accident. And so when I talk to people on the phone or in person, I'll say, did the police come to the scene? And if so, did they give you a report or a report number so that we can order it online for you? And then I'll get that report as quickly as I can get my hands on it, and I'll read it and see what the officer's conclusions were. In most cases, they're pretty crystal clear, like a rear-ender collision or somebody running a red light or a T-bone running a yield sign or being struck from behind. These are all pretty clear liability cases. But sometimes you get a case where it's not crystal clear and there's a disagreement, in which case you have to maybe go a little bit further and investigate the nature of the accident. And one of the main ways of doing that is there any camera footage? A lot of intersections have cameras. You can get film from those or from nearby businesses. Another way is looking at the damage reports. Where was this car struck and by whom? That if somebody was struck in the rear, it's almost impossible to disprove liability when you struck somebody in the rear, okay? because there are very few instances, maybe 1 out of 1,000, in which you cannot be at fault after striking somebody in the rear, okay? So some of them argue themselves quite easily. Other ones you have to go out and get a little bit of proof for it. But the police report is always the best place to start. And then maybe get reports from the claim adjusters who handle the vehicular damage. They also have pictures and all kinds of information as well. And once you put the pieces together, the liability usually becomes pretty clear.
I see. I see. You mentioned police reports. I'm curious about other documentation, things like, medical records or treatment history. What role those play in how a case is evaluated.
Well, the ABCs of any injury, let's say a car accident case, let's say a person calls me and hopefully they call me very soon after the accident. That's when I like to hear from them the most, because I'll sometimes give them advice for things that they may not have thought of or done themselves. Like I always tell a person, the very first thing you should do after getting in a car accident is go to the emergency room, okay? Because you may have injuries that aren't clear to you. You may just think you have a headache and you'll take some Tylenol and go to bed, when in possibility you could have a low-grade concussion, or you could even have a traumatic brain injury and you didn't even know it before you went to bed, in which case all kinds of problems can happen. So I tell them, first and foremost, get a thorough emergency room checkup at your closest hospital. Urgent care is okay, but not as good as a real hospital would be, because they have more facilities and more testing available at a big hospital. And then second of all, report all of your injuries to your primary care physician, okay? Because I want their records to show that you came in a timely manner to your family doctor and augmented your medical treatment by reporting to them. Even if they can't treat you or do anything for you, now there's a paper trail that you reported it not only to the ER, but to your family doctor. So those are two things early on that are important to preserve, your medical care in a case. And then usually once you go to your, say, family doctor, maybe they'll refer you to a specialist. A lot of times they don't treat people with back and neck injuries, but they may refer you to a specialist who does, in which case that could be what we call a PM&R doctor, physical medicine and rehabilitation. It could be a pain management doctor, could be an orthopedic physician, could be a chiropractor. But somebody should take over your care at that point and then move you forward on the medical chain of treatment. So I would say the first thing, ER, second thing, go to your PCP, and then third thing, get referred to a specialist and begin diagnostics and care.
Interesting. Yeah, I could see. I mean, that makes total sense, having that paper trail. And, as you were talking about earlier, where, objective versus subjective being very hard to prove, I could see how, hey, listen, I was feeling pain. I didn't know what they were, but I immediately went to, ER. I went to my doctor to, even if the tests don't show that there's a broken bone or whatever it might be, there probably helps my case to be able to demonstrate that I was feeling these things.
Once a claim adjuster or defense attorney gets hold of the records, that's what they're looking for. One of the things they love to see, and we hate for them to see, is that you went several months without care after an accident, okay? Because they're going to say, oh, all of a sudden, 6 months later, you got all this care. Why is that? If you were really hurting like you say you were, why didn't you get care right away? So, not only for the case, but for your own personal care, it's important to get timely care, get it quickly, and get diagnosed and get into your treatment quickly, as opposed to waiting and waiting and waiting, because that will hurt the value of your case later on, because they will remind you of it at every different stage of the proceedings, that you waited a long time to not get care.
Yeah. Well, and that's actually indicative of the fact that, sometimes the injury or the pain of the injury doesn't show up till later, but that still means you need to be have taken the right steps early.
Yes.
To head that off. That's good advice. You mentioned that not doing so can really jeopardize the value later on. Are there other early missteps that you see that end up hurting people's cases?
I would say, like, what I call the ABCs to begin a case are, your medical care, ER, PCP, get to a doctor quickly and get your treatment started. Obviously, reporting the claim to your insurance company. Okay. That's a big one. You want to make sure that there's full documentation. Some people have full coverage, so they're going to want to get their car fixed or replaced. Other people only have no fault, which means they don't have coverage on their car. But either way, you got to report it to your insurance company immediately. Get a claim number, get a claim adjuster assigned. They will assign you what is known as a medical or PIP adjuster, whose job it is to oversee the payment of any medical bills that may have arisen from that accident. But once again, you're documenting your injuries in a timely manner, okay? So you have to get your claim reported to the insurance company. Mistakes that you can make is not reporting it to them, just sitting and waiting and doing nothing with it and letting it float around for 2-3 weeks or a month before you report it to them. So then they don't even know it happened. And then what they're thinking is that if you report it that late, they're thinking, well, why are they reporting it this late? What are they up to? Is there fraud involved here? Did they just hook up with an attorney who made them do it? All kinds of thoughts that will go across their head. So, but if you report an accident like most people would, the day of the accident or the day later, then that's not even going to be a concern to them.
Yeah, I hear you. So to not do so, a red flag.
I would say take pictures of your car is another big one, because if you don't have full coverage, then the insurance company is not going to come out and evaluate your car and take pictures. So if you have just plain no fault, then I want a whole bunch of pictures of that car as soon as possible after the accident. And, by that, I mean a couple dozen pictures. Take it in daylight from different angles. And, because you're documenting things for a later date to prove what happened. And those can be reconstructed by specialists at a later date, both on their end and ours. But those early pictures are important. The first person you deal with on a claim is the claim adjuster, the BI claim adjuster from the at-fault party. It would be a PIP adjuster if the other adjuster is dealing with their medical bills and your household replacement services and lost wages and things like that. But the BI adjuster, the one who's responsible to pay for the bodily injury damage or tort portion of the case, they're going to look at the same things that I talked about to you already. What type of objective versus subjective results do we have? Has there been an MRI? Has there been a CAT scan? Have there been x-rays? Has there been ultrasound? What type of care have they received? Was it massage therapy? Was it chiropractic care? Was it formal physical therapy? They're looking at the hard data. They want to see the test results and they want to see what type of care you have received, okay?
Mm-hmm.
So I would say those are the main things that they're looking at their end to evaluate a case. They're looking at the hard data. What treatment have they gotten? What type of test results have they shown so far? If the person never gets an MRI or never gets a CAT scan, they're just going to presume that it's soft tissue injuries that go away in 2 to 4 weeks, and in your case is worth the very bottom level of appraisal.
Yeah. Put some ice on it. At what point does the possibility of going to trial start to influence how a case is valued or negotiated?
Different states have their own different ways of processing cases through the litigation system. Here in the state of Michigan, where I've practiced for over 40 years now, the very first thing we do is we file a claim with the insurance company who's of the at-fault driver on a pre-suit basis, introduce ourselves, sharing records if they wish. If it's a low policy limit, like 20 or 25,000, quite often I won't even bother filing a lawsuit, because at that point you're spending all kinds of extra money in litigation that could be going in your client's pocket. So you probably try and settle it without filing a lawsuit for a case like that. If it's a bigger case, then chances are you're going to have to file a lawsuit, because they're not going to willingly pay $100,000 or greater policy limit without all of the necessary proofs you have to go through. So you'd file a lawsuit at that point, and then it gets assigned to a defense attorney. And if it's $25,000 or more, which all of ours are, then we file it in circuit court. Okay, and that usually takes 6 to 9 months for it to work its way through the circuit court before you would get to a trial. I would say less than 2% of my files ever go to trial, because ultimately, once you've gone through the full litigation process, case evaluation, facilitation, sometimes binding arbitration, usually by then you're pretty close as to what the value of the case is with the other side, and you work out a compromise. Because one thing I don't want to do is jeopardize my client's payday, because juries are very, very unpredictable animals, okay? You can have what you think is a great case, and then you go to trial and the jury makes a decision completely out of left field. And then when you get to talk to the jury after the trial, which is the only time you can talk to them, they come up with the craziest answers you've ever imagined. It's like they weren't even listening to the same trial that you were in the courtroom for. So it's an unpredictable thing to throw it all before a jury, and I don't want to jeopardize a client's chance at a recovery unless we absolutely have to. In other words, we're so far apart that it's not even reasonable what they're offering, and then we have to put it before a jury. So I'd say 2% or less go to trial, and all the rest get settled at one of the various stages leading up to that.
Got it. Hey, walk us through a situation where the value of a case changed significantly based on how it was handled. Do you have anything off the top of the head that would be illustrative?
A period of time ago, I tried back-to-back wrongful death cases in the same year, 3 months apart. One of them was a 1-month jury trial. One of them was a 2-week jury trial. The 2-week one involved the wrongful death, police brutality against the Detroit police officer in the city of Detroit. The other one involved a street sweeper that accidentally ran into a vehicle on the roadway and ended up killing a 9-year-old girl. And
Wow.
and sometimes things will happen during the course of investigating a case, because when you're talking about a commercial policy, you're talking about $1 million or more in coverage. So they're going to fight it hard. They're going to put all of their resources into challenging every aspect of your case. And in that particular case, there were questions about liability that had to be proven. So each side had to hire multiple experts, okay? So in doing all of that, what changes? Sometimes you find out things during your discovery, okay? Discovery is something that the court rules allow for us to find out as much as we want about the other guy's case, and they get to find out as much as they want about our case. One of the methods by which they do this is interrogatories, which are legal questions that have to be answered in detail and within a certain number of days. Another way is depositions, where you give sworn testimony under oath, nowadays by Zoom, but they used to all be in person. And then a third way is independent medical exams, where they get to, if somebody's alive and hurt, they get to send you to their doctor to see if he agrees with the findings, okay? So sometimes things happen during the course of discovery that will change the value of a case. If you want me to give you an example from my wrongful death case involving the street sweeper, I became aware of the fact that this particular company was really a hazmat company. Their job was to go out and collect hazardous materials at various industrial and waste sites and whatever. But they had a side business where they owned 8 street sweepers. And they told their hazmat drivers, if you want to pick up some extra money, the keys are on the hook. We have these contracts to clean streets. You can go out and moonlight and make extra money cleaning the streets in our street sweepers. So a number of the truck drivers would do it. But what I came to realize is that since this wasn't a company that specialized in that, they were giving them no training whatsoever. They were just saying, keys are on the hook, go out, clean the streets, make sure you put the key back and fill it up with gas at our tank here. And that was it. No training. So what happens? One of these street sweeper drivers, who was really a hazmat guy by trade and had no training whatsoever, decides to help somebody on the side of the road on the expressway who's pulled off to the side of the road and appears to be, needing help. He pulls over to help them without putting out flashers, without putting out the candles, without breaking down the lane of the highway in advance so people could slowly get out of their lane as opposed to suddenly get out of their lane. So what happens? A guy comes driving along, can't get out of the lane quick enough, and hits the side of the street sweeper, causing a horrible damage to the vehicle and killing the little girl in the back bench row. Okay? And so we came to find out during discovery that they didn't train these drivers. They gave them absolutely no, what do you do if your vehicle breaks down? How do you pull off to the side of the road? What is proper protocol? Using flares, using candles, using oscillating lights, no training, just complete. So that was something that, as you asked, changed during the course of the case that made it a lot more valuable, because now I was able to bring account for negligent hiring, training, and supervision, and argue that before the jury, and take depositions of trucking experts who said what they should have been doing when they let these trucks go out on the road, certified experts in that field, and take depositions of the people who ran this company, making them admit on the stand that they gave no training. One of them even hired his ex-con brother-in-law to be a truck driver, okay? No, his ex-con, son-in-law, okay, to be a truck driver. And that was his formal training, okay? So what can change during the course of a case that makes it more valuable? The biggest and most important thing would be things that come up during discovery, okay? You don't stop researching the case just by filing the lawsuit. You're doing discovery once you file the lawsuit, and you're learning more and more and more. And in that case, I equated that you, as a plaintiff attorney, you have to be like a dog with a bone in its mouth. You have to go after every single instinct you have and go after it fully and not let go of the bone.
I hear you. Well, listen, we're up against time. Mark, thanks again for being here and for sharing your expertise. And I know we'll talk again soon.
Thank you.
That's it for today's episode of Detroit Auto Accident Law with Ravid and Associates. To learn more or schedule a free consultation, visit their website, ravidandassociates.com. You pay no legal fees unless they recover for you. I'm Sean O'Connor. Thanks for listening, and don't forget to like, subscribe to the show, and leave a review if you found this episode helpful. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.